Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property and property law. Today, we are talking about the fourth question, holding interest in property, and we are focused on the leasehold. We'll talk about four kinds of leasehold estates: the term of years, the periodic tenancy, the tenancy at will, and the tenancy at sufferance. Courts always want to characterize a leasehold in one of these ways because it helps them understand what rules to apply to the landlord and to the tenant involved in the dispute. So first, let's talk about the term of years. So this is a lease for a fixed period of time, probably the most common type of lease. Both landlords and tenants like term of year leases because it provides them with some certainty about the duration of the lease. It also releases them from the burden of notifying one another of a proposed termination. If one party wants to end early, there is usually some negotiation that goes on. A tenant is more likely to be able to break a lease if the rental market is doing well, and the landlord can find a replacement tenant very easily. Usually, tenants staying longer is not a problem because landlords like to minimize turnover. The second type of lease, the periodic tenancy, is a lease for a fixed period of time, which renews automatically for succeeding periods. These can be created by implication. So, for example, if you have a year-long lease that you pay monthly and then you hold over past your lease without a written agreement, state law might say that you have a periodic month-to-month tenancy, or might say that you have a periodic year-to-year tenancy, depending on the jurisdiction's rules. Under common law, in that same scenario, you might have had to give a full 6 months notice on a yearly lease. Some states have modified that common law requirement, which was fairly lengthy. If the tenant in a periodic tenancy does not give notice in a timely manner, the tenant is still on the hook for rent payments for the remainder of the re-upped period. If the landlord doesn't give notice in a timely manner, the tenant would be allowed to stay for the following period. The third type of lease is a tenancy at will. It lasts for as long as the landlord and tenant wish to continue. Each party has the chance to give notice to terminate, usually in an amount equal in time to the period of rent payments. This is like renting a hotel room. You can leave at any time. Termination can also occur upon death. By the way, that's not the case for a term of years or a periodic tenancy. If the tenant dies, the tenant's estate will be on the hook for the remainder of the term. If the landlord dies, the landlord's estate will have to allow the tenant to stay for the remainder of the term. I am including here a fourth type of property interest, the tenancy at sufferance. This is different from the other three types of leaseholds in this video because a tenancy at sufferance only arises when a tenant holds over after a lease ends. At the time of the holdover, there is not the kind of agreement between the landlord and tenant that we see in the other three types of leaseholds. In fact, the landlord may treat the tenant as a trespasser, go through the judicial process of eviction, or in some cases, engage in self-help. If the landlord sees some benefit of keeping the tenant, however, the landlord may allow the tenant to stay through the tenancy at sufferance. In many instances, a tenancy at sufferance will become a periodic tenancy, with the tenant being obligated to pay rent for the applicable period. So those are the four types of leasehold interests. I'll let you ponder, and I will leave it there. I look forward to connecting with you on Twitter or through my website, where you can sign up to my mailing list. See you next time.